Mr. Morelle.
Yeah, I don't have much to add. I just wanted to make what I think is a clarification. It's been suggested that a former president can assert privilege, but I believe it transfers to the office. I don't think it's the individual. I don't think the human being makes that. I think it's the current president who would make a determination. And I think what happens in practice anyway is past presidents designate someone who represents their interests in conversation between the National Archives and the current office holder, and the current president makes those decisions. That's the way it's done.
Well, that's in the narrow ruling for the archives. Yes, that's what Trump T. Thompson.
No, but I think in any case, I think even if it's outside I think the National Archives is where those papers are. That's where the material is. But I think even when it comes to claims of executive privilege, that the current office, it goes to the office, not to the individual. The individual doesn't, as I understand it, doesn't make that determination. It's the office of the president, whoever happens to be in the office. Now, that'll be litigated, I'm sure, but I don't think President Trump has the right to exert executive privilege. I think the determination will be by the president.
I think that at the very least, that question's unsettled.
I don't know that it's unsettled. You may challenge it with the existing Supreme Court, but I think that's how it's been determined in the past. The other thing I would just note, I mean, Nixon lost. I mean, it's a qualified privilege. Privilege is not absolute. It's qualified, and I think the court ruled unanimously that Nixon, because he was engaged in wrongdoing, the court unanimously ruled against him. And I would argue that on January 6th and the weeks leading up to it and the weeks leading after it were about overturning illegally an election that had been decided, for which there was no evidence of fraud, as I said with the earlier testimony. So I would actually argue what they were engaged in was wrongdoing. It violated the Constitution. And so if you're engaged in sedition, you don't have the ability to argue, well, it's executive privilege. If you're engaged in wrongdoing, to overturn the Constitution or overturn the law of the land, the members of the administration, even if they're giving advice, as you've described, if you're engaged in an unlawful activity, that's not protected. You would agree with that. You might not argue that they were engaged in wrongdoing, but I assume you would argue you cannot extend privilege for wrongdoing.
And I think the first Nixon case and not the second case said for the very specific things on that is in criminal cases. This is not a criminal case.
No, but I don't know that it's not a criminal case.
Well,
if it ends in sedition,
then we have a legislative function problem in a really quick hurry.
Well, it could end in a criminal case. This is not a criminal case. It's the oversight of Congress, which has the right to do oversight, has the right to subpoena witnesses who they believe can give information that's pertinent, but it doesn't mean that there isn't that. I mean, in my view, they're protecting what is wrongdoing, and wrongdoing is that's not protected. But it'll be decided perhaps. But neither Mr. Navarro or Mr. Scavino chose to appear. I mean, I also assume that Mr. Scavino could appear and answer. I mean, clearly has some information that even he would argue would be pertinent to the inquiry, which would be outside the scope of you're arguing that it's outside the scope of the inquiry. Some of the questions, some of the things that were asked for outside the scope. Is that not what you argued?
Yeah, I think there's a subpoena that has 15 things. There's document requests, there's testimonial requests. Throughout the course of the correspondence, that expanded to 33, plus the catch-all. They could never come to an agreement on either the document request or narrowly tailoring of what the testimony would actually be. And his lawyer simply said, we cannot adequately prepare our client for coming in here under these circumstances.
So, but there wouldn't be a point in arguing about the specifics if you were going to assert that none of it was, that you weren't going to share any of it because of executive privilege. If the executive privilege ran to the whole thing, why would you argue about all the specifics that are underneath that?
I mean, they make the executive privilege argument and that Trump has asserted it, but there's a duplicative argument from the archives. There's a narrowly tailored argument. There's a lot of things. And listen,
But why would he go back and forth and have that argument about particulars if he believes it's covered under executive privilege?
Well, I'm not his lawyer, but I'm not sure until you get to that point they know what is and isn't covered.
And yet he didn't decide to comply with part of the subpoena. He didn't agree to say, I'll come and testify about the following. We can argue about the other ones. I'll come down and testify and give depositions about the following things that I think are truly part of that are covered under the
I am
scope of the
almost
inquiry.
certain, and I don't know this for sure, that he was never given that option.
Yeah, I mean, I don't know that that's the case. Would you like to comment on that?
Yeah, but I'll just make the point that for every witness who is acting in contempt of the committee has said, come in and testify on those things that we agree are not covered by executive privilege, for example, or Fifth Amendment privilege, and then you assert the privilege, which is, as you know, Mr. Armstrong, the way defendants do it. You go to court, and if you think you've got a privilege, you assert it then. You don't blow off the proceeding.
Well, and I'd also, how does this get adjudicated, in your opinion? How do we ultimately decide whether Mr. Navarro and Mr. Scavino should be compelled to testify?
Well, you have Trump v. Thompson, you have Trump v. Mazars. If your answer is to actually compel the document production and the testimony, the civil enforcement action is the way to go. I don't think the criminal contempt motion is going to get the committee what they want, but that's just my opinion.
So your argument is we just sit around and wait. Congress doesn't do anything until the court cases are decided at the Supreme Court?
I think everybody who has a subpoena issued to them has the right to have a neutral arbitrator determine it when they have a legitimate legal dispute.
Well, it seems to me that ends up in and I think this is by design, just a stalling tactic to make sure we wait years and years, if necessary, to get to any information. I mean, I think that's the whole point of this.
Mr. Morelle, if you want to work with me on a way to make the federal court system work faster all the way around, I am absolutely.
I'm sure I would agree with you on it. I'll yield.